was Detective Howard got a airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all 3 defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
Was she made aware of that? Because I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days and played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Detective Howard brings it in, and while Mr. Lukowski is being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
Didn't go to her phone.
If I may.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Can you talk into a microphone? Yes. On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled IMG_0159.MOV. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Okay, go ahead.
And I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Krause was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Krause, and I asked for an exact forensic copy of what they had given to the state crime lab. ADA Krause responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file. Simultaneously, ADA Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4. So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Krause followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 millibyte file that I had gotten previously.
So clearly, Attorney Wisco's email is compressing these files. That's not our responsibility. Oh, I didn't write Outlook software.
You know what?
I forwarded.
But wait a minute, I don't know if she had finished.
No. Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have. The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar. The one that was provided to the state's crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone because they indicate a lot of different information like the location of the drone and the time. The file I received originally on Friday the 5th was not labeled that same and was not the same file amount. There's no way that what ADA Krause is saying is true because the file name would not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state, at least for what Attorney Binger gave me on Saturday. They're completely different.
I think we're confusing the issue here. The work product of the state crime lab is sent via Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on. The email from my personal Gmail account is the file that went to the state crime lab. I was told to bring it to the state crime lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab. I don't know if Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone as the title that she indicated. That was the one that went to the crime lab, and I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly,
Well, obviously we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this, who has some competence, which,
If you look at the report from the state crime lab, they indicate the originating file that they received was the one with the expanded title that we did not
Right.
receive until Saturday. If it had been the same file as 88 Kraus says it is, why wasn't that labeled on their receipt as being IMG 059 or 159?
Mr.
If that
Kraus?
is the exact same thing, then that does not add up.
Mr. Kraus?
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the state crime lab. I had no other access. At this point, the first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
We're going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it
Yeah.
multiple times, and it all saved it as IMG 0159.
Okay, well, you know what? We can't resolve this now, because this is going to require expert testimony from people, and we're going to have to take testimony under oath as what the facts are, and so I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit, this is a high-risk strategy for the state. I was queasy about this from the beginning, and I'm only queasier about it now.
Judge, what we propose is to show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Binger didn't even mention it in his closing. We didn't show it in either our closing and rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the image that the court is received over objection. But the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they are somehow prejudiced is preposterous. I understand it's previous counsel, but it is still the defendant's attorney He was charged with this crime, and if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir. Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given...
I want to stop you now.
Okay.
Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from...
Black and white.
Ah, that was, okay. Go ahead.
And we stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding you,
Can we
Judge.
put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that that should be
Can I
marked
run a
into
compromise?
evidence.
This isn't, let's make a deal here.
Well, they did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive that was everything was going in.
And I thought we gave them a full and complete copy of the video. So.
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number.
Well,
How can I not give it to them? You tell me.
I mean, then I would ask that evidence that's been admitted also go to the jury, that has been legally admitted in front of the jury, and follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there was an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15/10/31. If you look at our video that we were provided, the metadata, the create time is 21 minutes and 19 seconds later.
Judge, we're looking at the Tucker Carlson interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition, like this video. We're watching, it's online, you can watch it.
The one I have is black and white.
Mr. Rittenhouse, attorney, has seen the real version.
What about that? If his prior attorney, he's got it.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this urban air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report, I don't have it with me. And the individual lives out in the Lake Geneva area. And he lied to our investigators and said we are mistaken that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video, and then it shows up on the Friday after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
I don't know who was interviewed. I believe that is the owner Mr. Beeman? Oh. Okay.
I'm shaking my head no. I answered no to Mr. Carlson's question. I apologize.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So, well, if we're moving on, at least for the moment,
Let's move back.
let's go to number 4.
Yeah.
So it seems that the request, it says view video, but I believe it's actually, I believe 3 videos.
I did not hear you, sir.
It asks for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night. That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number because it's on a drive. We do not object to it being given a number and sent back, or well, played however the court deems appropriate. So we would ask that. So I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, and that's by agreement. And then the question is where and what restrictions will be put on their use of those videos.
The state's position is that they should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave, and they can discuss it. Now, it says...
all by themselves, or...
by themselves.
Okay.
Just as they are
I
in the jury
assume
room.
that somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. They can be given a computer with you just plug it into the side, and then they can just press the thing. If there's...
Computer, it doesn't have other matter on it?
We have, I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence of this case on it. It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
Judge, we were talking about it, and the question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
Any more than if they had paper exhibits and they were discussing them. And certainly the defendant can't be in the room while they're talking about them.
Well, I agree with that.
Why is the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No. I want to go back a step.
Okay.
Supposing I said, well, let's just get a computer that has nothing else on it, or that everybody feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer, whatever, and then send that upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately, they're not here yet, because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry.
Who's okay with that?
We are okay with that.
Is based on what you said. So we're not waiving anything on 5.
You're not waiving anything on 5.
Then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Kraus?
We can, this one,
One of those?
I have to look at it, but it can be cleaned quickly.
Look at it. Well, I'm going to go and do something else. I've got. Well, I'm not going to go. I'm going to stay. I'm going to stay and do something else, and I'll let you fellas try to work this up. And
At this point, Your Honor, they have not requested what we're fighting about.
they have not requested.
At this point, they have not requested what we're fighting about.
You are correct.
Okay.